Is a verbal agreement legally binding? The short and simple answer is yes. A verbal agreement is legally binding provided all the fundamental legal elements that make an agreement/contract valid exists. These legal elements are offer, acceptance, consideration, and intention to create legal relations. The exception to this is where the law specifically provides that a type of contract or agreement must be in writing, such as the sale of land or real estate, leases longer than 1 year, agreements and contracts covered by specific law, etc. But there are issues that comes with not having a contract or agreement written. The major disadvantage is the problems that arise when the agreement or contract is to be enforced. Some of these issues include: 1. Disagreements around the existence of the agreement/contract between or among parties. 2. Disagreements about the actual terms of the agreement/contract between or among parties. 3. The parties to the verbal agreement/contract might not have the authority to enter into the verbal agreement in the first place. 4. There are some complex transactions that verbal agreements/contracts would not be suitable for. In summary, a verbal agreement can be legally binding. But this is dependent on factors that are mentioned above. It is advisable to create a record of the agreement even if the agreement is verbal. This can be done by documenting the discussion and confirming the terms of the agreement via email or written correspondence. Alternatively, you can consult legal experts in ensuring that your agreements/contracts comply with legal requirements. Legal disclaimer: the content in this video is for general information and education purposes only and should not be construed as legal or tax advice. We do not warrant or guarantee the accuracy, completeness, adequacy, or currency of the information in the video. You should seek the advice of a competent lawyer licensed to practice in your jurisdiction for advice on your particular situation.